Welcome to the McNees Litigation Podcast Series. This podcast will continue to cover the driverless car phenomenon by James Franklin, attorney at law. Mr. Franklin is a member of the insurance law, litigation, and the transportation, distribution, and logistics practice groups at McNees.
Previously, we've talked a little bit about autonomous vehicles or self-driving vehicles and the unanswered questions and legal issues that they present. And these issues include, are these vehicles safe? What happens if they're involved in an accident? And if they're involved in an accident, who's responsible and how are they held accountable? Well, two recent events have once again pushed these issues into the spotlight and once again emphasized that these issues and questions remain unanswered, unaddressed, and that they're even evolving. One event occurred in mid to late March of this year. In Arizona, an Uber-operated autonomous vehicle was involved in an accident and resulted in a pedestrian's death. Now, Uber and various state and local agencies have launched investigations, and it's unclear yet what exactly happened. But what they're trying to figure out is, did the technology fail? How was this person struck? Why were they struck? Was this accident preventable? Was it not preventable? Now, if this accident couldn't have been prevented, if these vehicles aren't 100% safe or can't be made 100% safe, that brings us to the other issue of, well, what happens when they cause an accident? Who's accountable? Now, the answer to that question has really run the gamut. We've seen manufacturers recognizing the safety concerns come out in defense of their product, saying they think these cars will be safer than human-operated vehicles, saying that they will be willing to guarantee and stand behind their product. The other end of the spectrum, we've seen people come to the defense of manufacturers and trying to insulate them from potential lawsuits or some type of lawsuits. For example, there's a piece of legislation currently before the Senate at the federal level called the AV START Act. And that legislation, what it may do is prevent riders of self-driving vehicles in some instances from suing the manufacturer for defects, for accidents. It may prevent people from joining class actions against the manufacturers. It may force drivers or riders in autonomous vehicles into arbitration against the manufacturer. Now, arbitration is generally seen as a pro-business, manufacturer-friendly way of resolving a dispute. So some pro-consumer groups are opposing any such language or loopholes that would force arbitration. Now, it remains to be seen whether the statute will be passed, whether it will be modified, what else may come in to address this issue. What's important, though, is that these questions currently are unresolved, they're evolving, but they're of paramount importance not only to the manufacturers, not only to folks that may buy these vehicles one day, but really the entire public, because sooner or later, and it's probably sooner, every one of us is going to have an interaction with these vehicles in some shape, form, or fashion. So it's key that we know what these answers to these questions are and that we address them sooner rather than later. The transportation, litigation, and personal injury groups at McNees Wallace Nurick regularly monitor for updates affecting the motoring public. If you would like more information on this topic, please contact me using the information on the screen. Thank you.